5 seconds to go. Start. On behalf of A6 and A7, it is submitted that there was no motive for the said accused persons to have indulged in the commission of the offence in question. The motive, if any, existed only for the remaining 5 accused persons who were interested in the outcome of the pending litigation between the parties. It is further contended that the High Court ought not to have entered into the exercise of reappreciation of the entire evidence without finding any infirmity in the view taken by the trial court. To buttress this submission, it is submitted that since the view taken by the trial court was a possible view, it could not have been disturbed by the High Court in appeal. In this regard, reliance has been placed upon the decisions of this court in State of Goa versus Sanjay Thakrar. It is further submitted that no reliance could be placed upon the testimonies of PW2 and PW4 as their presence at the spot was doubtful. Further, if they were 400 yards away when hue and cry was raised, they could not have seen A6 taking away PW18 towards the well, as the said fact took place prior to the hue and cry. It is further submitted that in the FIR, no pistol was assigned to A6, whereas the said fact was brought forward at the time of evidence. The appellants have also raised a question regarding the time of incident on the basis of medical evidence. It is stated that the post-mortem report indicated that half-digested food was found in the stomach of the deceased, whereas the informant PW18 deposed that the incident took place immediately after dinner. If such was the case, the death ought to have occurred around 1-2 am in the intervening night of 30th August 1985 and 31st August 1985, but the post-mortem report based on the post-mortem conducted at around 5:30 pm on 31st August 1985 indicated that death took place about 24 hours ago, and thus the time of death was around 5 pm on 30th August 1985 and not 10 pm as alleged. The appellants have also submitted that the prosecution has not proved that the deceased was actually residing in the concerned house at Simaltala. Per contra, it is submitted on behalf of the state that mere non-examination of some independent witnesses shall not be fatal to the case of the prosecution. Reliance has been placed upon the decision of this court in Rai Sahab and others versus State of Haryana to contend that at times independent witnesses may not come forward due to fear. It is further submitted that the High Court has correctly appreciated the evidence in order to arrive at the finding of guilt of the accused persons. It is further submitted that the testimonies of PW2, PW4 and PW18 are consistent, and the High Court has correctly placed reliance upon their testimonies. As regards motive as well, it is submitted that the evidence is sufficient to reveal motive for the commission of the crime. We have here learned counsels for the appellants as well as for the state. We have also carefully examined the record. Stop.